A judge has ruled that Donald Trump and his two of his children, Donald Jr. and Ivanka, must testify under oath in a New York State investigation into their business practices. This is a civil investigation being conducted by the New York State Attorney General, and the judge ruled that the Trumps, they were subpoenaed in December. They must comply with that subpoena within 21 days. There's every indication from lawyers for Donald Trump and for Don Jr. and Ivanka that they will appeal this ruling, and that could take some time. That could really protract things. They eventually want to stave off the possibility that their clients have to testify. Lawyers for the Trumps, for the former president, and for his two adult children, Don Jr. and Ivanka, they argued that this testimony that they are being subpoenaed for could be used against them in a parallel criminal investigation being conducted by the Manhattan District Attorney's Office. Now, that's the investigation that last year led to criminal charges against Trump Organization Chief Financial Officer Alan Weisselberg, and also the Trump Organization itself. Those charges allege that extra benefits, untaxed benefits, were passed from the company to that executive, Alan Weisselberg. They've pleaded not guilty. Now, of course, anyone giving a deposition, anyone testifying can plead the Fifth Amendment, their right to remain silent, the right to not incriminate yourself in your testimony. But lawyers for the Trumps argued that that could complicate things nevertheless. If Donald Trump, for example, were charged with a crime, potential jurors would probably have some awareness of this whole fight over his testimony. And, with that news splashed across front pages and websites and phone alerts, that lawyer says it would be impossible to get a fair trial for Donald Trump because jurors would think that maybe he had something to hide if he invoked that Fifth Amendment right.